All right, folks, it's showtime. All right, folks, question. How many of you have a clear plan as to what will happen with all your possessions if you were suddenly to leave from this world today? That's exactly what we will be discussing today on this webinar. As you know, our topic is understanding, or let's call it demystifying, estate planning. And I'm your host, Brian Dougherty from PLC Financial Solutions, located in the Fort Washington, PA area, along with my beautiful, wonderful partner in business and life, Rachel Dougherty. Say hi, Rachel. Rachel's going to be our moderator for tonight, as always. She will be handling the chat and Q&A boxes at the bottom of your screen. But before we get started, let's take care of some general housekeeping first. If the screen is not big enough for you to read, you can click on the View Options drop down at the top right of your screen to make it larger. Also, you'll see that there are two boxes at the bottom of your screen. One called Chat, it's for your comments, and the other called Q&A for your questions. Please use them accordingly, and Rachel will respond to them in kind. Next, I'm sure that many of you guys will have questions about the material as we go along. However, since we have a good bit of material to cover and only an hour to cover it, I'm going to ask you to put your comments and questions in those boxes below, because at the end, we'll be staying for some extra time to cover as many of them as possible. However, if we don't cover yours, we'd be happy to answer it by either email or even a 15-minute Q&A phone call scheduled for another time. Rachel will be posting a link for you to schedule that at the end of the webinar. Next, this webinar is being recorded and it will be sent to everyone who is attending tonight. So don't worry about missing anything. You'll have plenty of time to check it out at your convenience. Also, because we want you to make sure that you're all paying attention, and because we'd like you to have some fun as well, before we answer any questions, we have a 6-question quiz for you at the end, and the first person to answer each question correctly inside the comment box will win a $10 gift card to a store of their choice. So make sure you have a notebook handy to jot down some notes from some brief bullet points that I will point out as we go along. Finally, it's my obligation as a financial advisor and a fiduciary to inform you of our RIA's disclaimer statement, which is that our investment advisory services are offered through Fusion Capital Management, an SEC-registered investment advisor, and we only transact business in states where we are properly registered or excluded or exempted from registration requirements. Also, SEC registration is not an endorsement of our firm by the Commission and does not mean that our advisors have attained a specific level of skill or ability. And most importantly, all investment strategies have the potential for profit or loss. So now that we got over that, I have one for you as usual. You're going to be surprised, Rachel. It's another new one. Why are ghosts such bad liars? Because they're easy to see through. I love it. I didn't even get that from the kids either. So, all right. But I'm sure you're going to tell me, as usual, keep my day job, right? Okay. All right. So let's get started. So welcome to our Understanding Estate Planning webinar. It's our third time presenting this topic since last year, but since it's such an important topic, we decided to add it to our annual rotation of workshops. That all being said, we have so much to share with you today. We'll be providing answers to the most commonly asked questions on the topic and providing valuable information and perspectives in regard to the more basic aspects of estate planning. Things like, what is the difference between a will and a trust? What's included in each? What does a power of attorney do in regard to my estate? Will I need to appoint guardians in my situation? What is the best way to structure my beneficiaries? I think you get the point. This is a lot of important stuff, folks, and we already and we all really need to figure out before we kind of move on from this world, before it's too late. So on that note, let's jump in. So what is estate planning anyway? Well, estate planning is the process of reviewing your assets and belongings to determine how they're going to be preserved, managed, and distributed. Assets include real estate, cars, stocks, artwork, life insurance, pensions, and yes, even debt. Proper planning also considers the management of your financial obligations in the event you become incapacitated. For these reasons, estate planning is an essential component to your overall financial plan. It allows you to gain more control over various aspects of your life, both during your lifetime and after it. So I'm going to say this a few times tonight to stress the point. Please seek out the assistance of an experienced attorney in estate law to do this. It's absolutely essential to have your financial wishes fulfilled. A financial advisor like myself or someone else can help you to put a plan together to limit taxes on your estate, guide you through the process of legal documentation, and even declare how your estate should be handled after death. But I 100% advise you to seek out an attorney who specializes in estate planning to carry these things out. First, let's talk a little bit about why many folks seem to avoid putting a sound estate plan together for themselves and their families. Well, the overwhelming number one reason for this is something called cognitive dissonance. And this seems to be the number one thing when you look up estate planning, seems to be mentioned a lot. And what is cognitive dissonance? It's the state of having inconsistent thoughts, beliefs, or attitudes, especially as they relate to behavioral decisions and attitude changes. It occurs when a person holds contradictory beliefs, ideas, or values, and is typically experienced as psychological stress when they participate in an action that goes against one or more of their beliefs, ideas, or values. In other words, it stresses people out. That's the bottom line. Also, here are some interesting statistics that you may relate to. So 47% of people say they need a will or trust, but they haven't gotten around to it. However, a survey by Merrill Lynch asked, how would you characterize someone who died without their affairs in order? Interestingly, 88% of the people chose words like irresponsible, inconsiderate, and ignorant to describe people who check out from this life without their affairs in order, yet 47% haven't gotten around to doing it. So that's pretty crazy. I think we think that and still don't have the time to do it. So let's look at what may be causing these contradictory beliefs. So most people imagine that they have plenty of time to get their affairs in order. And most of the time, this is what leads to a lack of urgency. Unfortunately, putting off estate planning places you and your family at a significant disadvantage in the event the unthinkable happens. In addition to this lack of urgency, many people feel intimidated by confusing jargon and the potential expense associated with estate planning. Some also fear the process will be emotionally demanding and time-consuming. And let's face it, some people just don't want to think about themselves dying, which just causes you to keep putting it off. So I know myself, no one likes thinking about their dying. Anyway, all right, so let's say that we've gotten over the cognitive dissonance / plain old stress we feel related to this stuff. What are the main steps we need to take when it comes to creating our new estate plan? When creating your estate plan, there are 5 major decisions you will need to address. First is, who will get your assets when you pass away? Whether you wish to leave your assets to children or gift them to your favorite charity or other loved ones, you'll need to dictate this by naming beneficiaries. Designating heirs for your assets is the main component of estate planning. Individuals and families who do not have an estate plan are at the mercy of the court when it comes to deciding who gets what. This process can take years sometimes and rack up fees, depending on the size of the estate, pretty large, and can get pretty ugly if it's not planned out properly as well. The second decision you'll need to make is the method of distribution. This involves determining how your beneficiaries will receive your assets if you were to pass. Depending on the age and financial capabilities of your beneficiaries, you may wish to delay distributions as well. So you may stipulate that young beneficiaries receive their portion in stages rather than one lump sum. Some people designate a specific portion of their assets to be distributed at certain ages or even in various ages as they mature. The third decision is deciding who will be your financial power of attorney. Your trustee and or executor to make decisions for you in the event that you can't make them for yourself. The person or persons you name should be someone who is responsible, especially financial, and is capable of handling finances for you and is generally a good decision maker. Some people prefer to name a professional trustee rather than a family member or a friend. Generally, I recommend naming 2 or 3 successors in order of preference to my clients, because you never know if one of them will predecease you. The fourth decision is deciding who the person or persons will be as your healthcare power of attorney. They can be the same or different from your financial power of attorney. This is the person who will make healthcare decisions for you in the event you cannot. You should appoint someone who can make decisions during difficult and emotional times. This document also allows you to state your end of life and organ donation wishes. Again, we usually recommend naming 2 or 3 successors in order of preference as well. The fifth and final decision will be determined who will have legal custody of any minor children should you pass, if you do have children. Your appointed guardian will work with the trustee to access funds for the care of your children. The best person for this job is someone who will care for your children in a similar manner as you, of course. Think about the values you wish to impart and the level of care your children will need. Many people name parents, siblings, or close friends as their appointed guardians. Naming again multiple successors in order of preference is recommended here as well. Okay, now that you have a better understanding of what goes into estate planning, let's talk about the 2 major components that can facilitate its execution, and that is wills and trusts. Let's begin by defining a will. A will, or a testamentary will, which is its full name, because it's your last will and testament as a living person, is a legally enforceable document outlining how your affairs and assets should be handled after you die. A will is going to contain provisions which control or dictate to whom your property is distributed. While having a will in effect in an effective way to transfer your estate and other legal proceedings following death, you should be aware that your estate will become part of the public record. This is because anything left via a will must go through probate court. Unlike retirement accounts and life insurance policies, which pass straight to named beneficiaries. Again, I can't stress enough here, in order to create a legally binding and comprehensive will, you should definitely seek out the assistance of both an experienced financial expert and legal counsel who understand the fine points of doing so. Now, a trust is another method of estate transfer. And there are many types of trusts to choose from, depending on the function you wish to carry out. Things like a special needs trust, or irrevocable trust, or a revocable trust, or asset protection trust, or a charitable trust, or a constructive trust, or a spendthrift trust, or a tax bypass trust. They go on and on, folks. And like a will, a living trust will require you to transfer property after death to loved ones. It is also known as a living trust. All trusts are known as a living trust because it is created while the property owner, also known as the trustor, is alive. As the trustor, you can make changes to the trust at any time while you're still alive, as long as it's not irrevocable. It's the only kind you can. However, unlike a will, a living trust passes property outside of probate court, which means your assets can be passed directly to your named beneficiaries without court involvement holding up the process. A lot of people really would prefer this to be a private matter. There are some noted similarities between a will-based plan and a trust-based plan. First, both a will and a trust allow you to control who gets your assets at your death, how those people or entities get your assets, and who is in charge of making financial decisions at your death. Second, both wills and revocable trusts can be changed provided you have the mental capacity to do so. Also, both documents are set in stone upon your incapacity or your death, meaning no changes can be made once you are either declared incapacitated or you have passed. Now let's discuss the differences between wills and trusts. When it comes to wills versus trusts, there are actually more differences than similarities. First, a trust will avoid probate if funded properly, unlike a will, which is created in order to tell a probate court where your assets should go. On that note, in some states and situations, probate can be costly, time-intensive, and most documents are public record, meaning anyone can show up to find out what's going on and to find out who's getting what. However, if done properly, trusts are far easier to administer and are completely private in nature, while wills become public record and can take years to distribute, especially if they're contested in any way. Furthermore, a trust is more comprehensive than a will, because it allows you to control both what happens now while you're still alive if you become incapacitated, and what happens at your death. While a will, on the other hand, only controls what happens at your death. When you have a trust-based estate plan, you also have a will that goes along with it. And that's important because if you did not put all your assets into your trust, the will would then govern at your death where all your assets will go. Sometimes people forget to put some stuff in their trust. The will would then dictate that. The beneficiary of your will is your trust. This is what is referred to as a pour over will, because it pours all of your assets into your trust at your death. Additionally, in a number of states, the will is the primary place where you can name guardians for your minor children. It's usually only in the will where that can be stated. If you have named beneficiaries on your assets, life insurance or retirement accounts, for example, the beneficiary designation of those accounts controls and supersedes your will. This is why it's always important to make sure your beneficiary designations are in line with your estate plan. So which is right for you? In most cases, if you're trying to space out distributions for your beneficiary, such as minor children, avoid probate, and want to exercise more control over things, you should consider a trust-based estate plan. However, if all your assets are going to pass to your heirs via beneficiary designation through either life insurance and our retirement accounts, like IRAs or 401ks, and there's no reason to hold things back from your adult beneficiaries, a will-based estate plan may be all that you really need. But if your situation is more complicated than that, then you probably should consider creating a trust-based estate plan. Just like many people review their financial plans on an annual basis, it's recommended that you review the circumstances surrounding your estate plan on a regular basis as well, or at least when life events occur, such as births, deaths, changes to marital status, or when anything happens that may affect your final wishes. However, some noted times that you should consider making changes to your will or trust include things like changes to health or wealth, relationship change to your power of attorney, trustee, or guardians, real estate changes, tax law changes. It's not uncommon for old trusts to sometimes have language in them that are based on old tax laws, which can sometimes increase the taxes on your beneficiaries. So, how important is estate planning? Well, folks, estate planning is really all about protecting your loved ones in the worst case scenarios. The primary benefits to estate planning include things like the ability to choose who will inherit what among your possessions and valuables. It affords you the chance to name your children's guardian in the event of your unexpected death. It can, in some cases, help reduce taxes on what you leave behind. And because it minimizes the chances of family strife, it can also help to prevent ugly legal battles that, unfortunately, sometimes occur when these details are left for others to deal with. Also, a good estate plan plans for as many contingencies as possible. Remember, they say in life, you should always have a backup plan. The same is true after you die. This is why I recommend naming several backup trustees in your plan. Estate planning is the only way to ensure that your final wishes are carried out, especially when it comes to your assets and your family. The goal, of course, is to leave nothing to fate. Folks, grieving over a loved one is stressful enough. Having a plan in place allows your family to focus on what matters during those difficult times, rather than them trying to decipher what your wishes may have been. More often than not, families who do not have a will or trust fall into disarray, sometimes even going into battle over what they think they deserve from you. Believe me, this type of strife can damage these relationships permanently in some cases, and it can easily be avoided by creating an estate plan before it's too late. So I strongly encourage you to do so as soon as you can. If you want your assets and your loved ones to be protected following your death, you're going to need an estate plan. Without one, your family could not only be left dealing with a lot of extra stress and personal challenges like those we just mentioned, but they could also be faced with significant tax burdens as well. And to top that all off, without a directive from you, the courts would end up designating how your assets are divided, and even who gets to raise your children, if that applies to your situation. So as you ponder this very important topic, please keep all these things in mind. Now, this is a pretty short one today, folks. These are some of the, Rachel's going to put up the sources that we used for this webinar in our comments box. And that concludes the learning part of our workshop for today. And I hope you were paying attention, because this is when things are going to get really fun. Let's get started with our 6-question questionnaire. You ready for this, Rach? Short but sweet tonight, right? All right, here we go. Question number 1. What is the first decision in building an estate plan? It's the very first thing that we covered. And I'll give you a hint. Who gets your stuff? Anybody? Come on, folks.
Yep, I've got name Benny, so name, beneficiaries, obviously.
That's right.
That would be Bob.
Let me guess. Where do you want your card from, Bob? Walmart? I knew it.
Got it.
Okay, what are the 2 major components of an estate plan that are used to give directives and dictate how your wishes and your assets are transferred? We just talked about it. The 2 ways people do it. One is when you die, it dictates it. And the other can dictate it while you're living as well. Come on.
Oh, Bob got it again. Bob and then Pepsi. Will and trust. Trust and will.
Patsy, good job. Okay, number 3. Which component of those 2 can only be used after death? The will. Good job, Patsy. All right.
The split one.
There, number 4. Are there more differences or similarities between wills and trusts? I said it. There are more differences.
That's a tough one.
Differences.
Yep.
Number 5. Between both a will and a trust, which bypasses probate court? Trust. You got it, Patsy.
They're racking it in.
Okay, final question. Between both a will and a trust, which does not allow for a private process? The will. I think we got 3 and 3, right?
That's awesome. Smarty pants.
Smarty pants we got here.
All right.
All right. So now we could jump into a few questions if anybody has them. I want to let everybody know I am not an estate attorney, and I basically just help people guide things through this, but I can answer some basic stuff. So if anybody has any questions, let's jump at it.
All right, there's a couple here in the Q&A. Do you want It says, can you hear me?
Yep, I hear you.
Okay. What do you think is the most important thing to consider on what type of estate plan I should have?
Okay, I think that's pretty easy. You mean between a will and a trust? I would say it depends on how complicated your situation is. In some instances, if, like we talked about earlier, if you just have life insurance, which has beneficiaries and retirement accounts, then you already have beneficiaries named. If your children are older, you have no children, okay, then you have very little need for any directives of any sort. You could probably just go with a will. But if you have a more complicated situation and there's specific things you want, especially if you have children or grandchildren or anything of that matter, and I just want to note, also, if there's bank accounts, they're not part of retirement accounts. You need to designate beneficiaries on them. Most people don't do that. So there's a special form that you have to fill out at the bank to let them know who you want to leave it to. But it's also the same for real estate. If you have real estate and that can get complicated, you definitely want to have a trust of some sort to name things, even just a regular brokerage account. It's not an IRA or 401k. That needs to have special paperwork filled out to make sure that it gets passed on. If you have that done, sometimes if you don't have real estate either, but if you have real estate, you have those types of accounts and you have children or grandchildren or whatever, I'd say a trust. It's a little more complicated.
Okay. Another one, how expensive is it to create an estate plan?
It ranges depending on the complication of it. In a situation where you have beneficiaries and you could probably just do it with a will. Sometimes you could actually do a will, although I do not advise this. Some people do their own wills, go online, and you can do a will. I recommend an estate attorney to do a will because they should be done in the right way. Otherwise, that's another reason how it can get messy in probate court. So it could cost, probably do a will for anywhere from $300 to $500 if you have the right attorney. But even a trust, hey, listen, I've seen attorneys charge $7,000 to $8,000 for a trust, a really complicated trust, and even sometimes for ones that aren't that complicated. So it really depends. But the better attorneys that I've talked to usually charge between $1,500 and $2,000. If it's complicated, maybe $3,000. Some of your more simpler cases, I generally help clients get it done for less than $1,000. And that's for a moderate, not, super complicated, but not also super duper simple either. So I would say the best ones you could do for $1,000 or under. They could get as high as $2,000 or $3,000 with a good attorney who's fair. And can get outrageous if you don't do, you don't go with a fair attorney.
Okay. All right, ready for another one?
Yep.
One more. Is a will just as legally binding as a trust?
Yes, absolutely. The main difference is really who carries it out. Like we talked about, for a will, although it's legally binding, who's interpreting it and who carries it out is a judge in probate court. A trust is carried out by a trustee. Who you name those trustees we talked about for either financial or health or whatever have you, power of attorneys, but there's a trustee that the assets pass to. that will carry out whatever your desire is. And that can be done quickly and privately. It's all arranged in advance. But they're both just as legally binding.
Okay. Want to do one more?
Yeah.
Yeah, okay. All right, last one that's here is, who is party to a trust?
Well, that's a good one. So there's also a couple in the, I see a couple questions in the Q&A, Rach.
All right.
Yeah, so the owner who transfers the property is known either as the settler or sometimes called the donor or grantor. I hear grantor used the most. The person receiving the property is the trustee. That's the person who's going to carry things out. And the person for whose benefit the property is being held is called the beneficiary. So there's three parties that are property. They could be all the same person, or they can be all different people, or you could be two people. So it just depends on how you do it.
Okay. All right, and there's should we talk to a financial advisor prior to seeing a lawyer to do our will?
I think it's a good idea, especially because I like to try to, I have some attorneys that I think are fair priced with these things, and have done good work for us in the past. And so generally, and it's like having somebody to screen the case, because this way can kind of know what level to take it to from a financial point of view. And if it could be expedited through quicker process, sometimes you don't even need a lawyer. Even if you have a moderate situation, there are some easier means to do it. So yeah, I think a financial advisor who's, who's familiar with trusts, at least, estate planning to some degree, and at least the ins and outs of it. I think it's just a good idea to have someone who can help screen your case with you.
Should we put the deed for our house in our adult children's name?
Yeah, obviously I've seen it done, and it can be done. I would be careful with it, because if also too, if you got into a situation where you needed to go into nursing care, they have a 5-year look back. Not that somebody would be, if they're doing it for estate planning, they wouldn't necessarily be thinking about that, but it probably wouldn't be honored for nursing care. But it's not a bad idea for estate planning, because there are some fees involved in that. So you have to look into what there's some taxes for transferring. There's a transfer tax in most states. I know there is in PA. And it could be $7,000-8,000 to, with a transfer tax. So you definitely want to find out the details when it comes to that before you go doing it. Because you could get hit by your estate at the end of the year, which I have seen as well. But it could be effective. But you can also, I know there are ways to do it in trusts as well, but you got to be careful, because they could hit you for the transfer tax in advance as well, with your real estate. So I hate to be elusive, but I think it can be done if it's done right. In that case, something like that might be worth talking to a real estate attorney just to make sure it was done correctly. But otherwise, it's not a bad idea.
Okay, there's a simple one. What is the trustee the same as an executor?
It is for a trust. Executor has to do with a will, and a trustee basically does the same thing for a trust.
And it looks like there's one more here. What is the difference between revocable trust and a trust?
all trusts are revocable unless they're declared irrevocable. So like I named all those trusts, they're all revocable unless they're declared to be irrevocable. So it's a big difference, because irrevocable means you can't go back, can't change anything while you're alive. But trust has to be designated as irrevocable. I think that looks okay, right?
Yeah, it looks like it did.
We have plenty of time on this one. I love it. 7:40. Okay, let's see here. All right. Okay, so now I hope that you found great value in this information today, folks. I want to thank you for taking this time to learn more about creating your estate plan. While making plans for your assets and wealth after death isn't anyone's definition of a good time, that the alternative is far, far worse. I can guarantee you that. Remember, you can save your loved ones from a logistical and emotional nightmare by putting your wishes in writing today. With that said, if there is anyone attending this workshop that is interested in creating a comprehensive estate plan and would like to learn more about how to do that, I'd like to extend out to all of you a no obligation complimentary 60-minute consultation on how we can help you to get that done. Rachel will be pasting a 60-minute meeting link in the comment box now. Did you put that up yet, Rach? So you can go to our calendar and book it for a time that is convenient for you. Also, if you have any questions, either in regard to this topic or in general about any other financial matters in your life, we'd be more than happy to discuss them with you as well in a complimentary 15-minute Q&A phone conference at a time that works for you also. Rachel's will also be pasting the link for you to book that on our calendar as well. You can also find both these links on our website at plcfs.com. That stands for PLC Financial Solutions. Or you can go to plcfinancialsolutions.com too. But the short one's easier, plcfs.com. You just click on the book now or schedule a meeting tab on our navigation, or at the top right side of all our pages on our site. Or you can also call us, just a novelty, right? Call us like the old way at 215-804-9708. Our phone number is on our website. Rachel can put that on the comment boxes as well, 215-804-9708. And we'd be more than happy to discuss whatever's on your mind with you directly, in person. You can actually talk to somebody, and we answer the phone 99% of the time. I don't want to put a guarantee on that. Also, folks, next month, we'll be back on our normal schedule for our monthly webinars. Yesterday, the last Tuesday, was Rachel's birthday. Happy birthday, Rachel. She was X years old. I don't want to say it. The last Tuesday of every month is when we normally do our webinars. Next month, our topic will be understanding long-term care and how it may apply to you on Tuesday, May 31st at 7 p.m. That's all for today, folks. For myself, Brian Dougherty, and my wonderful, beautiful partner in business and life, Rachel Dougherty of PLC Financial Solutions, located in the Fort Washington area. Have a great week, and we hope to see you next month. See you guys.
Good night, everybody. Thank you.